Now, after losing my appeal at the Court of Appeal, I filed an appeal at the Supreme Court. Yeah? Because I was still pursuing for my reinstatement as the governor of Mombasa.
Yes.
So I filed an appeal.
You went to a higher court?
A higher court?
Yeah.
The appeal was just lying there. Yeah? But what shocked me, and I want the world to listen to this, what happened to me should never happen to any other Kenyan in future. The Supreme Court set a very bad example in my case. Yeah? And I want to address the Supreme Court in a very respectful manner. I respect all the judges who are there.
Yeah.
But if they go wrong, we must address them in a very respectful manner.
Yes.
Currently, there is a boycott by the LSK.
Yes, right now.
Yeah, right now. Remember, in my case, some of my cases, LSK, they were party to my case. But let me come to this particular case. They did a very grievous or grave blunder, which will not be repeated.
Yes.
Yeah? A day before this judgment was delivered, Chief Justice Martha Koome ordered the Deputy Registrar of the Supreme Court, by then she was a magistrate, the Honorable Letizia Wachira, do a hearing notice to Sonko's matter. We want to hear him on the 14th. There are some allegations which I cannot talk about them right now.
Okay.
Yeah? I just want to focus on the law and the facts. Are very bad allegations against the CJ and what transpired that particular night. All the calls, what was done, who made a call from State House, But let me not go to that. I don't want to provoke her. She's a mother, she's a CJ, she's a sister, she's a, she's a human being. Because she's not here to defend herself, let me not go there.
Yes.
Yeah? Let me deal with the law and the facts. Now, what the CJ did, she instructed the Deputy Registrar Supreme Court, circulate a hearing notice for the Sonko's impeachment case. We have to hear him on the 14th of July 2022. Remember, my judgment was being delivered on the 13th July 2022.
Yes, just a day later.
Once we got this communication from the Supreme Court of Kenya, directing us, these are the directions which I would like to read. Owing to the urgent nature, which agency? Well, I had filed my appeal since May. It was lying at the Supreme Court, whatever portal or registry. But here the Deputy Registrar, through the instructions of our respected Chief Justice Martha Koome, she's saying that the respondents do serve their responses before close of business on the 12th July 2022. Remember, I have a judgment on the 13th of July.
Yes.
This is a CJ who has sensed that Sonko's judgment is going to be delivered in his favor.
Okay.
Then the petitioner is at liberty to do a rejoinder and serve the same upon the respondents before midday of 13th July 2022.
The next day?
The same day my judgment was being read.
Okay.
She knew very well I'll be with my lawyers. Waiting for the judgment to be delivered. Then the same days you suppose you and your lawyers to file all your evidence, all your submissions, all your affidavits, file and serve. Relax. File and serve to the respondents. What did we do? And then she's saying here that the matter will be listed for hearing of the petition before a 5-bench judge on the 14th of July, 9 a.m.
The next day.
You're just given some few hours. And those few hours, you are spending them at the High Court of Mombasa, waiting for your judgment to be delivered with all your lawyers, all of them. Because this was a sensitive matter concerning my political life. Telling you that as that judgment is being delivered, you serve file your respondents in our Supreme Court matter. What did we do? We protested. And this was after the judgment was being delivered, because we were all concentrating on the 3-bench judge, which was delivering my judgment for me to be on the ballot. So my lawyer protested in the evening and told the Supreme Court, no, you guys were wrong. You are forgetting that we just filed our appeal. The Supreme Court has not given us directions to prepare and file our submissions and affidavits and serve to the respondents. This is a matter that had got over 14 parties.
Yes.
And they were in the process defying their own Supreme Court rules.
Yes.
Yeah? What does the Supreme Court rule say? I have them here. Okay, in the interest of time, we will not go to the details of but I'll just quote it. I'll just quote it because I want to flow. I don't want any of my point to evaporate. This is the Supreme Court rules. I think either rule number 22A or 25A says, if you have an active appeal which you have filed before the Supreme Court registry, the next thing, you should wait for the directions
from the court
to be given from the court by the deputy registrar.
Yes.
And this is how it should be, because I'm conversant to some of these laws, that the deputy registrar will write to the parties, and myself being the appellant or the petitioner in this particular appeal, the deputy registrar was supposed first to write to me.
Yes.
Now the court is ready to have your appeal or to listen to your appeal. Put your submissions, serve to the respondents. Then when the respondents are served with the submissions, they will respond. They will do responses to your submissions and file. They'll also be given some time.
What is the stipulated amount
maybe
of time?
within 14 days.
14 days.
Yeah.
Okay.
To file. Once they file the responses, I'm also given some more time, between either 7 to 14 days.
So both teams are given
they're given
a bit of time.
14 days. Okay.
For me to put my submissions and serve. Okay,
upon
once they receive now my submissions, we have what we call response. They do a response to my submissions. They're given time to read
and to reply.
Yes. Once they reply and file and serve, I am entitled to do what is called a rejoinder.
Yes.
I'm also given time. To read their responses and to do a rejoinder.
Okay.
After doing this rejoinder, now I serve them. After serving them, what happens? We have what is called a pre-trial conference, either physically or virtually. Now, when you go for a pre-trial conference before the DR, the DR is supposed to look at the Supreme Court diary and check whether compliance was done by all the parties in the matter. Oh, Sonko's lawyer, did you comply with the directions of the Supreme Court? Yes. Your Honor, my Lord, everything is filed. The respondents, everything is filed. Yes. If anyone has not filed, he's supposed to raise
objections.
And say, my Lord, I'm sorry, I've not finished. I need more time.
Okay.
You are giving time. Okay? Then, if everybody has complied, the DR now says, we have a diary here. We have this date, maybe 20th of August. Is this convenient to the parties? Each lawyer will talk on behalf of their client. No, Songo's lawyer. No, my Lord, that day I'll be having a matter in Nakuru court. It's not convenient to my client. Can we take another date? Okay, then let's check the diary. We have the 30th of December. No, the lawyer for county assembly. No, my Lord, that is not convenient. So you are supposed to engage until you get a convenient date for all the parties.
Also, they engage and actually give you access.
No, what was done to me was an ambush.
Okay.
They did not comply with the law. Sijui alikuwa anataka na nini Supreme Court. They didn't follow the law. My appeal was just lying there at the Supreme Court. Haraka ilikuwa ni nini? Kuni ambush na the judgment inasomwa. So it was wrong.
Yeah.
Yeah?
Yeah.
So that was not done.
Yes.
And when we appealed, I mean, when we protested, what did the Supreme Court do? They checked their records and found that they had missed. They had not issued, they had not given directions for the responses to be filed by my lawyers. What did they do? They did an email to my lawyer. To my lawyer. No, there's another one. There's another one. This is the same. Oh, here. They did an email to my counsel. Good afternoon, counsel. Now, this is attached herein. Please see a letter from the Honorable Registrar and the directions. Please acknowledge receipt. This is from the Supreme Court of Kenya. Email Supreme Court Kenya at gmail.com. Another email Supreme Registry at court at go.ke. What were they saying in their letter? They are writing to Nyamu, Republic of Kenya, the Judiciary, Supreme Court of Kenya, Taifa Road, City of Baba Nyamu and Nyamu Mayfair. Reference Supreme Court Petition number 11 into brackets E008 of 2022, Honorable Mike Bubisongo versus the Clerk, Nairobi City County Assembly, and 11 others. Okay, I'll read the letter for the world to know what transpired. I refer to the above subject matter in which directions were issued on the 11th July 2022. Yeah? My judgment was coming 2 days after this.
Yes.
The High Court judgment, which was ruling in my favor. It has since come to our attention that due to inadvertent mistake, they are admitting inadvertent mistake, directions were not issued in respect to the petitioner filing submissions in support of the petition.
So they admitted.
Now they are saying, this is the Supreme Court.
Yes.
We apologize for the oversight and hereby enclose further directions for compliance by the parties. Yours faithfully, Honorable Letizia Wachira, Registrar, Supreme Court of Kenya. She's now a judge. She has been promoted to be a judge. The letter is copied to all the parties. Yeah? Here's where the biggest blunder is. You have admitted that you have not given me directions to file my responses to this very important appeal about my life. Yeah? You are apologizing that you have done a mistake. But you are doing further directions and forcing me. Nothing changed. Let's see. What does the further directions, which were given on the 12th July 2022, yeah? Remember, my judgment was being delivered a day, some hours even after this, some hours.
On 13th
July 2022.
At 9 a.m.
The further directions say, now further to the directions of the 11th July 2022, the following directions are hereby issued now. The new directions. Listen to their game. Nothing changed. Even there was no point of apologizing. Nothing changed. The petitioner do file, now me. These are new directions. Do file and serve a soft copy of his submissions by midnight today. The 12th midnight. While I'm preparing for my judgment on the 13th.
On 9 a.m.
Yes, 9 a.m. The respondents are at liberty to file and serve a soft copy of supplementary submissions by 10 a.m. on the 13th day of July.
On the same...
So these submissions, they read within 2 hours at night to respond by midnight.
And then serve.
Is this a kangaroo court? Let's proceed.
Yes.
By 13th, 10 a.m. Remember this 13th, 10 a.m. I'm where? Before the High Court 3-bench judge. Empaneled by the same Chief Justice who issued these directions. The same 13th of July. I'm being told, leave court and go, prepare then the petitioner at liberty to file a soft copy of any rejoinder by midday, by noon of the 13th day of July 2022. Then all had copies and filed responses and submissions to be availed at the court registry before 2 p.m. the same day my judgment was being delivered. And remember, these documents are very voluminous. I'm being told to leave court with my lawyers, go prepare hard copies and take to the Supreme Court in Nairobi while I was in Mombasa with my lawyers waiting for our judgment to be delivered. Is it a kangaroo court? Haraka ilikuwa ni ya nini? Hata presidential petitions, they're not being conducted in this way.
They're not in a hurry.
This same bench was empaneled by the CJ. The CJ knew my judgment was ongoing on the 13th. The same 13th I'm supposed to do my responses and file. Meaning leave court with my lawyers, fly to Nairobi, prepare hard copies, file at the Supreme Court registry, opposite City Hall. Then go back to Mombasa for the judgment. And a hearing notice. I'm sorry if I'm provoking the Supreme Court, but I have to talk. This is about my life. Yeah, the same CJ through the deputy registrar, and I respect them a lot. They are doing a hearing notice and say that by Thursday 9 a.m. my matter must proceed by force. Isn't this how we conduct hearings? What was the haraka ilikuwa ni ya nini? Nani alikuwa amemharakisha lazima animalizie the same day? Article 25 of the Constitution has been defied. Article 50, right to fair hearing, right to fair trial. Yeah? Now, another worst thing. On the 14th in the morning, in the direction they say, the matter will be heard by a 5-bench judge. We found 7 judges. This is deceit, misleading. We found 7 judges. Yeah? And the one who was in the chair, presiding judge, was our Honorable Chief Justice Martha Karua. And I want to repeat, I respect our Chief Justice.
Not Amkome, not Karua.
I mean, sorry. I'm sorry.
Yes.
Martha Kome.
Yes.
I have a lot of respect for her.
Yeah.
So I want to address the Supreme Court in a very respectful manner. Yeah? We told the Honorable Judge, you at Spice FM, talking about my impeachment. I'm one of the affected parties. Yeah? And before a public TV station, I'm sure she breached the Public Officers Ethics Conduct Act, whatever. She was not supposed to go to a public TV station to talk about my case. This was just some few weeks ago, talking about my case in a live TV, saying impeached governors will not be allowed, contrary to what the Constitution says. Yeah?
That you have to exhaust all avenues.
Yes. And 2 benches, the Nairobi bench presided by Majanja and the Mombasa court, they have said Article 196 of Article 3 stands. While her, she misled the world, she misled the public, she misled Kenyans, that once you're impeached, that is the end of your life. That was wrong. Okay, we told Our Lady, can you recuse yourself from hearing this matter? Because you had already formed an opinion. She's saying, where is the evidence? Well, she knows very well she did not give us time to bring our evidence. That is a public clip by Spice FM. We could have downloaded and used it as evidence. She knows she was there, but she said, bring evidence. She knows she did not give us time to give the evidence. And she knows she came here. So she could have just recused herself and panel another bench. I'm allowed the other judges to proceed. She had already formed an opinion. I knew I was not going to get justice. So she forced my case. My matter proceeded. And it is very painful on the 14th. My political life ended on 15th of July, just some few hours. A file that had over 1 million words, 14 parties. I don't know what time
To go through
the proceedings in the file. My political life ended on the 15th July 2022. Within some few hours. Even the presidential petitions, the parties are given time. Yeah? Even judges, they break. They go somewhere for a retreat to write these judgments with their researchers. Kwa nini yangu ulifanywa haraka haraka mbio? Hearing ya High Court iko 13th. Unaambiwa file submissions on 13th. Hard copy Supreme Court. 14th hearing. 15th judgment. That's how my political life ended.
Very fast.
Very, very.
And I've not given up. 6 years down the line, I'm still fighting for justice. Yeah? I never lost hope. I was removed from the Mombasa. I was removed from the Mombasa ballot. Not because justice was served.
It's followed.
Not because just a law was followed. there were some orders from above, just Sonko should not be on the ballot. I never give up. Yeah?
Yes.
I took the war to the next level,
Yes.
which was the East African Court of Justice. I've been there for so many years
Yeah.
looking for justice. Yeah? I took all this evidence from the Supreme Court, all the apology letters, everything. I filed my matter before the East African Court of Justice.
Yeah.
Yeah?
Yeah.
The East African Court of Justice thought the matter is still ongoing. Why am I talking about this, Judge? I don't have any active review at the moment,
Okay.
which I'm intending to file any time now.
Okay.
So we should also respect the judiciary,
Yes.
the sub judice rule.
Yes.
Matters which are pending in court, we are not supposed to discuss them
We
live.
can't discuss, yeah.
But these matters have already been concluded.
Okay.
I've lost my appeal. Yeah, the matter before the East African Court of Justice is still active. I will limit myself
To it, yeah.
to. I'll just talk about what has already been delivered.
Yes.
Sawa.
Okay.
So the East African Court of Justice found. This is reference number 25 of 2022. Which page? Page 22. Page 22. This is not Sonko. This is the East African Court of Justice. They said the applicant, Mike Mbuvi Sonko, has established that there is a cause of action that depicts substance and reality. His allegations of procedural irregularities and denial of a fair trial are substantiated by evidence, including admission by the Supreme Court of Kenya of his procedural errors. The applicant has demonstrated that the Supreme Court could have failed to adhere to its own procedural rules, which, if proved, will be in violation of Article 25 of the Constitution of Kenya, which I've talked about it, and Article 6 and 7 of the Treaty of the Court. This court recognizes that the questions raised in the reference are serious and merit a full hearing of their substance. This is the East African Court of Justice. They have found that the Supreme Court of Kenya has violated its own procedural rules. And they ruled. They proceed in saying the applicant has also demonstrated that he will suffer irreparable harm if the orders sought are not granted. The Supreme Court decision to bar him for life from participating in political activities has profound and far-reaching consequences. Such harm cannot be adequately remedied by damages or any other form of post-facto relief. The impact on his political rights, reputation, and capacity to engage in public service underscores the irreparable nature of the harm he faces. This is the court that just say. Be that as it may, whereas on the case urged by the applicant, there will be sufficient ground to stay the execution and enforce of the Supreme Court judgment to do by this court, and will be an affront of the constitutional mandate of the Supreme Court of Kenya and in excess of this court's own treaty mandate. Now what's happened here? The Supreme Court gave itself some powers. There's an advisory opinion in a case of Martha Karua when she was challenging the President Ruto's election. Attorney General, the former one, who is ready to be my witness, is no longer in government now. He took a reference, to the Supreme Court. The Supreme Court in that reference, it gave itself powers and said their ruling shall be final. Contrary to Article 2, Sub-Article 5 and 6, which recognizes all the international courts. Article 2 of the Kenyan Constitution, Sub-Article 5 and 6. It says anything by these international courts, when some of the treaties which were ratified, they're supposed, their decisions to form part of our Kenyan laws. And that's the Constitution of Kenya, not Sonko. If anybody Googles Article 2, Sub-Article 5 and 6, it talks about all these international laws. So, we are still seeking for justice there. I've been granted leave. because the AG who was representing the Supreme Court of Kenya wanted file an preliminary objection, which was dismissed by the Supreme Court of Justice. They found my case had merit. Yeah. So I niliwapatia technical knockout on round 1. We are still proceeding with round 2. I'll not go to the merits, the details of round 2. Yeah. It includes damages and so many things. Now, since they don't want to implement this judgment, the facts which have been found here, there's a very comprehensive details of how the Supreme Court messed with my case. I'm supposed to use some of the declarations by the Supreme Court of Justice to make them as part of my review, which I'll soon file. I agree I failed in the first review. But you see, a review is when you have any new evidence. In any case, if any new evidence which comes, since we have even the outer, this outer, I don't know, this former politician, that might have been in the Supreme Court, it is our president that was set. If any new evidence, like now I put another crucial evidence, even the speaker, Yulalin impeach, has shown an affidavit and say he was intimidated to change the numbers.
Wow.